minors actually have the ability to consent without needing to first ask their parents to receive certain types of medical care. And these laws are usually around care like care for sexually transmitted diseases, or care for reproductive health, or care for mental health, or care for substance abuse disorders. And the reason why states allow really young people, usually not younger than 12, but the age actually varies. But the reason why states pass laws like this is because in some family situations, the minor would be reluctant to go get the care that they need if they had to tell their parent or get their parents' permission to do this. And so states make this decision that, and it's a state law issue, it's not a federal law issue. States make this decision that, again, certain minors of a certain age, and it really varies by state, are allowed to consent to that kind of treatment. Because they have that consent right for that treatment and they don't have to ask their parents, the minor can make the choice not to share that data with the parent. In patient portals, a lot of times that really sensitive data that's subject to one of these minor consent laws is commingled with the data that isn't subject to those consent laws. And so because the portal systems sometimes don't have the ability to shield some of the more sensitive information from the parent while allowing the parent to see the rest of the information that the parent is allowed to see, the portals make a judgment call that they'll just cut off that access when the minor reaches what is usually the lowest age at which, under the law in that state, they can consent by themselves to be treated.
Yeah, so the practice of health providers changing access to electronic portals and information at a certain age is tied to federal and state laws about consent and confidentiality. So in California, there are laws that provide minors, people who are under the age of 18, with the right to consent or not consent to some medical care. Typically, parents hold those rights for children, but not in all cases. So there's also a law that says when a child has the right to consent to medical treatment, then they control the access to the information about that treatment. So they control access to and release of their own health information. And a lot of the laws that give minors the ability to consent or not consent are triggered at the age of 12. So at that point, kids have a legal right to health information privacy, even against their parent or guardian. And that's what triggers those changes in healthcare information that you can access. And, I'm a parent of someone with a disability, and we noticed that we had full electronic access to our child's medical information for a while, and then it was restricted in some way. And that's typically triggered by those laws that provide minor access. So some of those areas where the state of California has decided that kids should have a degree of medical privacy to discuss their concerns with a doctor without their parents' knowledge are things like drug and alcohol abuse or treatment, mental health services, intimate partner violence, rape, AIDS or HIV services, and sort of all manner of sexually transmitted diseases. It's not all medical care that minors have the right to direct. It's specifically defined in some laws, but parents and guardians are restricted from viewing test results, upcoming and past appointments, information about mental health, reproductive health, substance abuse, some of those other topics that I mentioned.
So this is another situation where, in this case, the default is no access to the newly adult person's records because they are an adult, and that means everything in the record, not just the sensitive data that they may have been able to consent to as a minor. They have their own consent rights. They can seek their own treatment, even if that care is continuing to be paid for by the parent through parental insurance, they are still an independent adult individual with full autonomy to make decisions, except in a circumstance where the child is actually not able to make their own decisions. They have a disability of some sort. Maybe it's an intellectual disability. Maybe it's a developmental disability. Maybe it's a combination of a lot of disabilities where the child is unable to form the requisite intent to consent to medical treatment. And that's the threshold. The threshold is about, are you capable of consenting to your own medical treatment? And if you are, then the privacy rights go right along with that. But if you can't consent to your own treatment and you're a parent of a child that doesn't make their own medical decisions, you've actually got to get authorization from your state to be able to continue to make medical decisions for your child. And once you have that authorization, the privacy rights come right along with it. You'll be able to access the data because you're essentially the medical decision maker for that, for your child, who is no longer a child, is an adult in the eyes of the law. But the law also recognizes that some adults can't make decisions for themselves. We actually have a number of patients on our platform who have rare disorders that occur in childhood, where the symptoms begin during childhood, and where you're talking about children who have never made medical decisions for themselves and still are not able to do so as adults. But when you're in the role of a parent, there's a default assumption that the parent, except in those, circumstances with the types of care that I'm talking about, that the parent makes the medical decisions for the child. Once that child hits 18, then legally they're an adult until you take the steps that you need to take to get the legal authority to make medical decisions for them. How you do that kind of varies a little bit by state. I think sometimes you can online find legal forms, and for a very small fee, you can download them, fill them out, sign them, and get them notarized, and that's sufficient. There might be additional process required in other states. It's one of those situations where it can be very helpful for you to be like in a social community or working with an advocacy group that has the same disorder as your child, so that you can talk to other parents that have been through this, that live in your area. What did you do? Sometimes that your doctor or your hospital may actually have a social worker that actually knows exactly what you need to do in terms of the paperwork and the forms. And then you'll need to keep that paperwork because that's your ticket to fighting back and getting access to your child's data when they cut you off immediately.
In California, your child can give you permission. Most providers offer a written form, called a release. Sometimes it's called a minor authorization form, but different practices can call it different things. And it's basically a form that says, I would like my parent to have full access to my medical records, or you might be able to say access to this part of them, but not to this part. Your child can sign the form to permit you access to their medical records and their personal health information, and that includes electronic access. So the best way to figure out how to continue supporting your child is to ask the provider what is their process. They should be able to provide you with resources to help you understand what happens after the age of 12, how your child can consent for you to continue to have access to their records, and what's the process if your child is between 13 and 17 and does not have the capacity to consent. For capacity, so that's when someone is unable to understand their rights, unable to understand the right to medical privacy and to give consent to you having access. You need to have a direct discussion with your child's healthcare provider to find out how they intend to ensure that the right person is making healthcare decisions. So everything is fact dependent. It depends on your child's capacity, which is something that is a discussion. I would say even if a child lacks capacity to consent, the provider should still discuss their care with the minor in a way that's appropriate for their age and their understanding, and also involving their parent as well. So any adult in California, whether they are disabled or not, is presumed by the law to be competent, to have capacity to make their own decisions. And that's in the probate code. And so that presumption of competence means that for everyone, once you turn 18, you are managing your own confidential information. And the law also says that the mere diagnosis of a mental or a physical disability is not enough to say that someone lacks capacity to do a certain act, right? There has to be more information. It's not just, hey, I have this diagnosis, I have this disability, I guess I can't make my own decisions anymore. It's more complex than that. Um, in the lead up to turning 18, parents should have conversations with their child and with their child's healthcare provider to find out what will happen and how they can continue to support their child if that's what their child wants. So there are lots of ways to document that someone wants help, assistance, or to delegate their decision making to someone else when they're an adult. So you could have a durable power of attorney for healthcare. And in California, there's a specific form in the law that you can use. It's easy to look up on the internet. And someone who has capacity can say, I would rather that my mom make these decisions for me. There are different categories on the form where you can say what sort of decision making you want them to have. So a power of attorney, a durable power of attorney for healthcare is one way to document that. I think the tricky situation is when it's not clear if someone has capacity or not to sign a power of attorney, because most medical providers will say, oh, here's a durable power of attorney for healthcare. I understand what this means. It's not legally effective if someone doesn't have the capacity to understand what rights they have and what rights they're giving to someone else. But an adult can grant access to their medical records to any way they choose. If you have a child who you don't think has the capacity to understand their own medical care and make those kinds of decisions, you need to have a discussion with the healthcare provider about what kind of documentation they're going to require, because it varies from practice to practice. Some doctors might be comfortable saying, I agree with you. I'm familiar with your child and I understand their background and situation, and I've made a decision that they can't make these decisions on their own, so we're going to let you continue to have this access. Some doctors might say, well, if we don't have a form, we can't do anything about it. And then you get into the tricky situation of, does this person have capacity to sign a durable power of attorney for healthcare, or do we need a court order saying who is going to have the discretion to make their medical decisions? So at Disability Rights California, we don't help people conserve people. We do a lot of advice and assistance with identifying alternatives to conservatorship, and there's a few reasons for that. Anytime you involve the court in your life or the daily life of someone, that's going to be a burden. It can be expensive over time with legal fees and court fees, and it's also really kind of an invasive process of inserting the government into day-to-day decision makings that someone is making. Also in California, the law requires a court to consider what are called less restrictive alternatives before they can grant a conservatorship. So judges should be asking things of the conservator, like, what else have you tried? Have you tried supported decision making? Supported decision making is a process where the person continues to have their right to make their own decisions, but they've had full discussions and maybe even entered into an agreement with people who will support them in their decision making for different areas of their life. So an example would be if financial decision making, I might want to retain my own decision making, but I also need help understanding what things mean. And maybe my mom agrees that she'll explain financial issues to me, help me work through banks and paying my bills. That would be supported decision making, and it wouldn't require a court order. So, some things judges explore in conservatorship hearings are, okay, well, if there's a concern about financial management, Maybe have you tried having a joint bank account? Have you tried taking money management classes? Those sorts of things. And if the person who's seeking the conservatorship has not tried other options or can't demonstrate why they wouldn't work, the judge should deny the conservatorship. So it can be a complicated process. Um, so that's part of the reason that we don't participate in conserving people. We also have an organizational perspective that people with disabilities are entitled to direct their own lives, their own advocacy, their own decisions. So we try to maximize opportunities for that through our work as well. Um, there are lots of options other than conservatorship. I talked about a durable power of attorney. You can just write a written release. It's a document that consents to release your information or records to anyone else. Any adult can do that, whether you have a disability or not. Most of us are familiar with attending doctor's appointments and having lots of forms to sign. One of those is a HIPAA release. HIPAA is a federal medical records protection statute. And you can just sign a HIPAA release that says, I'd like my mom to have access to this. I'd like my best friend. You can delegate anyone that you want. Another option that works quite often with healthcare providers is just to have a third party making a phone call with you, calling the provider together and giving verbal permission over the phone. I'm here, but I want you to talk to my mom or my dad about this situation. And then the provider can document it in the notes and they feel free to have the full conversation in the presence of everyone. Um, then one other thing that I wanted to mention was that this is something not a lot of parents always know, but there is a law in California, and it's been the law for about 4 years now, that healthcare providers cannot charge fees for filling out forms to support claims for eligibility for public benefits. So a lot of times when you're a parent of a child with a disability, you need to go to the doctor and ask them to fill out all kinds of forms to document your child's needs so that you can get Medi-Cal coverage or in-home supportive services hours or eligibility for Social Security income. And it used to be that doctors could charge fees for filling out those forms, which would discourage some people from asking because the fees could be too expensive. But in California, it's the law that providers can't charge fees for public benefits forms. And that's just something kind of related, but I think it's important for parents to know.